Okay, it is 8:30 p.m. Central Standard Time, and welcome to week number 4. 4 already. And in this class, you know what that means. We have one more lecture, and that'll be next week. And that'll be the final lecture for the course. And I do want to let you know that a couple of things. Number one, I have not completed your week 3, your week 2 grades. Your week 3 grades aren't due until Friday, and they'll probably be a little behind as well. And the reason being is because I had a loss in my family. I lost one of my sisters over the weekend, and so I've kind of like been giving more attention to that, dealing with that, and still dealing with it right now as I speak. So I'm doing a little catch up, so bear with me. But I will get them done in the next day or so for week 2. And then the other thing I want to remind you again is it is so important to follow that rubric, that column that I told you at the right, so you can make sure you get your grades to the max when I do grade them. So you already know what column I always want you to go to, and that's the one at the right. So anyway, okay, I'm going to put that in there. So let's get to it. Let's share my screen. Oh boy. Yeah, I had 7 natural sisters from birth, all younger, and 1 from adoption. So 3 of my sisters from natural birth are gone. So that leaves 4 girls and me, and I'm the oldest. So it's pretty tough, and it wasn't even COVID related. She had other issues as well. So, all right, we are at week 4, and you can see that we have one more lecture, week 5. Thank you. We have week 5 coming up next week, and then I'll be discussing whatever assignments we have for week 6. So yeah, it's kind of hard getting through. I've done 2 lectures this week. This is the last one that I have to do for the week, and so like I said, it's been a pretty hectic week for me. So let's take a look at the course calendar. So bear with me. So today is the 27th. On Monday, I sent you the PowerPoints. I think I sent you the right PowerPoints finally. I sent you one was wrong and then one was right. So you have them all, the PowerPoints for week number 4 rather. Prisoner rights and evolution of probation. We're going to talk a little bit about that. Your initial post, intermediate sanctions, was due last night. Your reply post is due Saturday, 11:59 p.m. Central Standard. And then your assignments are due Sunday the 31st. Written assignment, probation officer. The quiz, which you're very familiar with now. You have 3 tries at that. And then the last thing is your live classroom lecture phrase or word that I give you. And notice this, that starting Monday, which is the 1st, and you have a lecture on the 3rd, and then if we go to the following week, you have a lecture the 3rd, move that up there, and then class ends on the 9th. Your initial post and reply post will be due, along with your quiz that you have. Okay. So we'll go over that next week. So really at the end, don't have a whole lot that you do for week number 6. All right. But just remind you that the class absolutely ends on the 9th, not the 10th, not the 11th, and won't go beyond that. So all assignments have to be in. I do want to tell you this, that as of Sunday, pay attention to what I'm about to say, that as of this Sunday, the 31st, any assignments from weeks 1, 2, or 3 that have not been passed in, with the exception of discussion posts, you can't do those because that's passed. But your written assignments, you can submit them, but if there's extenuating circumstances, you may get some points, but then you may not get very many points at all. So it's very important. So absolutely anyone who submits weeks 1 to 3 after Sunday, that actually by February 1st, you're out as far as that's concerned, because we'll be actually officially Monday, starting the second half of the course. Okay, remember this is a 5.5 course, so it's 5.5 weeks. That's why we end on the 6th week is a partial week. So let's go to the module. Look at the assignments. So intermediate sanctions, and so you're going to use this fact pattern, putting yourself in the position of a probation officer, and you're going to deal with this individual by the name of Pat and determine what you could do that's good. Explain the intermediate sanction that you think is good, or other intermediate sanctions. Support the selection, detailing why you selected it, and including any potential problems associated with it and any potential issues. So again, the initial post was due last night, and the reply post is due Saturday. Anybody have any questions about this week's discussion assignment? You can type yes or no in the chat box. I'll see it. Okay. So it's pretty explanatory. All right. By now you know how I grade those, because actually I graded weeks 1, 2, and 3. I think I did week 3 your discussion posts already, so I get those taken care of pretty fast. Now let's look at the written assignment aside from the quiz and the key phrase. So probation officer. So there's a county, an unnamed county, who struggle with overcrowding in jails. As you know, probation is a remedy that means that a person does not go to jail and they get to serve their time out using one of the intermediate methods, and utilizing that to help the person to matriculate back into society. And if they follow the requirements that are set out by the probation officer and the judge, then they'll be fine. If not, they'll have what we call VOPs, which is violation of probation. And you should be aware that violation of probation hearings do not follow the same standard as the original criminal case, which is beyond a reasonable doubt as the standard, but instead follows preponderance of the evidence for individuals who violate the probation. So in this instance, you are a person who's, just starting out, and you understand, as it says, the concepts of evidence-based practices and the many roles or hats that you wear of probation officers as you work with clients. Remember, you got social worker and counselor and other things. And so you've been told to create a job announcement for the new probation officer posting. All right, that accurately describes and details what probation officers do. That's the sum of it. And then your job announcement includes these bullet points that are listed below. Notice it says evidence from credible sources. I have already said this time and time again that in order for you to get the maximum grade and to get out of column 1, you must have credible sources. Of course, that's required because this is APA anyway. So that means you have references at the end, but really heavily leaning on the fact that you provide citations properly formatted to support your statements. And then your spelling and grammar in that. So you're going to have a cover page, double space, and you're going to submit it in a Word document. Okay. So basically what it is you're going to create an announcement. Now you could do that in the form of, the way you do a paper, but the language in there should, and I don't want you to use bullet points. I want you to do complete sentences and things of that nature. Sometimes students ask that point, which is a proper question. So you got to cover these issues. Continuing of probation officer duties, describe the 4 roles of a probation officer in fulfilling these roles: surveillance, broker service liaison of the court, change agents, interventions. And remember some of the things I just talked about a few minutes ago. All right. Now let's look at the rubric. So you can see that is due Sunday, and you see how important it is. Remember what I said. If you don't have credible sources, it's all the way down for every section of it. Examples of what the work is, description of each role, and summary of the continuing of the probation officer's duties using credible sources. Then you can't get either of these 2 columns because this is minimal and this is with some other details. But this is, if you don't have any, you automatically are going to end up over here. You cannot get here, you cannot get here, and you definitely cannot get here. So look at what happens here. You have 19, 29, 30, 31 points. 31, I think I did that right. 11, 11, 22, 30, yeah, 31 points rather than the full amount of 60 points, which you can get here. I can't even start to give you that. So, any questions? Okay. It's pretty straightforward. This assignment is pretty straightforward. And, get it completed. All right. So now let's take a look at what else we got, which you already know. The next thing is your quiz, and you know it's timed for 30 minutes, and you have 3 opportunities to complete it between now and 11:59 p.m. Central Standard Time on the 31st, which all your assignments are due. And you know it's supposed to be closed book, and you also know that I recommend that you study the materials, use the PowerPoints and information for review, pay attention to what's said in the lecture and what's in the module, and you should do well with the quiz. And then your live classroom lecture is due also on that same day. And those are the assignments for week 4. So let's talk about prisoner rights and evolution of probation. So your reading was 8 and 9. I think I inadvertently sent you chapter 4 and 9 at first, but then I sent you 8, I think later, but you got 8 and 9. So don't worry about that 4. And so we're going to talk about the law of correction and prisoner rights. And then we're going to deal with this, and we're going to conclude here. So we're not going to spend a long time on these because I want to try to finish up on time. So you should be aware of the fact that our laws are based upon several places that you can find them. And starting with the United States Constitution. So our laws should not violate the Constitution of the United States. And that the Constitution lays out the branches of government, which are the executive, which consists of U.S. President, the legislative, which is the House of Representatives, and the Senate, 435 members of the House, 100 members of the Senate. And then the judicial branch is the United States. It's always United States Supreme Court. The reason why you must say that is because of the fact that there are Supreme Courts in every state in the land. So you want to make sure that you state it that way. And then cases that interpret the statutes that are passed, as well as the U.S. Constitution, which, by the way, you should be aware the statutes are the federal statutes, as well as each state has its own codes, or statutes, laws that are passed by your House and your Senate in your respective states. And then there are cases where people have brought suits that relate to either the Constitution and or the statutes on the federal level or the state level. And so the court then, of course, interprets those cases to determine whether or not they are, number one, violations of the statute, or whether it violates the Constitution of the state, because many states have constitutions as well, and or the United States Constitution. And then there are various regulations. Now these are not quite, they're rules, as our laws are rules, but these regulations are, and we're going to talk about that now, rules made by the respective state, federal, or local agencies, and it's usually the agency for the executive branch that's designed to implement the policies of the agency itself as to how it operates. Okay. So then we have the Bill of Rights, which is the first 10 amendments, and as it says here, that the way that the laws operate, you're going to see here some cases that the courts kind of like would allow the case law or the statutes or regulations to control. And so finally, it reached the stage that it changed. So the states themselves didn't just decide it, but the federal government also decided, because you have federal cases. You have a lot of what we call Section 1981 cases. Those are civil rights cases which prisoners bring to claim that they have certain rights that are violated while incarcerated. And so the states' constitutions come into play as well. So let's talk about a few of the amendments. The First Amendment, as you already know, abridges no law shall affect the establishment of religion, which that's a common lawsuit that's filed to say that there are certain activities. People might even say lobby for a certain kind of food because of a religious diet. Maybe they don't eat pork because they're Muslim or whatever. And then, so the suits are usually used for that. Or they don't so much deal with the bridging of the freedom of press or the right of the people to peaceably assemble. But the primary one that's utilized in the First Amendment, you'll see, relates to privacy and things of that nature as well. Such as in 1962, when it recognized the religions aspect of it, that Muslims were recognized as a faith. Censorship of mail, that is, the mail they can go through and see the mail to the extent necessary to maintain prison security. As you may or may not know, that if you send a letter to someone who's incarcerated, that letter is screened for contraband and or certain types of pictures or language or things that might create a security problem in prison. In 87, the rights of Muslims, it says in the court case, are not violated when work makes it impossible for them to attend religious service, if no other alternative. Because people would say that they, to get out of work, use their religious beliefs. Incarcerated individuals don't have the right to receive mail from one another, and that's because of what I just said, because they pass notes and things to do plan escapes, insurrections, and so forth. And it can easily be banned, that mail, if it relates to a legitimate penological interest, once again, to maintain security and control of the facility. And then finally in 2006, prison can deny certain magazines, newspapers, to the most incorrigible residents in the prison in an effort to promote security, and rule complaints are constitutional. I will tell you that magazines can be utilized to smuggle in drugs. Let me tell you about an instance that I'm familiar with from a guy that I represented, who was a correction officer basically, and he lost his job because he was doing a favor for one of the inmates by bringing in magazines. And so he would bring the magazines in, and as some people may know, you can put razor blades and things like that in there, but that wasn't what happened. So the magazines that came in had a problem, and there was a problem with the magazines. It had nothing to do with the pictures or either the messages in it. Could have been a Sports Illustrated magazine or Newsweek. I bet you probably don't know what the problem is. Do you know what the problem was with that individual with those magazines? Anybody? Okay. Seems like nobody knows, and I'm not surprised you don't. These people are very clever. Well, the magazines he'd bring in, the inmate would get the magazine not to read, but to chew the pages. Why would they chew the pages? Now, do you have a clue? Yes, I said chew, like like that. Why would they do that? Any ideas? Well, chewing the pages would cause them to act crazy. There you go, Faith. There it is. That's it. The pages had been soaked in PCP liquid or some kind of drug and dried out and ironed out so that you couldn't tell. But the person would chew the pages and they would not necessarily swallow the paper, but they would get high. That's exactly right. You never would have thought of that, would you? Yeah, yeah. This happened in the early 90s. Yeah, that's when it happened. Yep. I'm going to say probably about 90. Actually, it was 90. It was mid 90s because it was like 94, 93, something like that. So the Fourth Amendment, dealing with search and seizure, as you know, in 1962, conversations recorded in a jail visitors' rooms are not protected. You should know that your conversations are being recorded. Now, the only time that conversations are not recorded is when? There are two occasions. Can you name one? What conversations are they not able to record? Nope, nope. How about attorney visits? Because of the attorney-client privilege. And another might be a religious or a doctor. Yeah, either of those two. Usually doctors don't take place in that scenario because they'll, you'll end up going to the doctor. They'll send you to a doctor. But attorney-client is attorney visits, because I used to do those, as well as um, yeah, your uncle does prison visit. What does he do? What is his occupation? Your uncle. Oh, okay. Yeah, but his is different because they totally have them in the examination room. That's not the same there. But mostly it's what I said earlier. Ministerial uh, or either and I used to have the unique thing of using being an attorney to do it, and actually my periods were longer than those even of a minister. So I had both best of both worlds. Most of us didn't, but so in 1972, a warrantless search of a cell is not unreasonable. That would make sense because they be able to uh, check to see if you're hiding some weaponry or something there as well. And you got to expect that when you're in that facility, that your privacy level is not going to be at a high level. Okay. Strip searches, including searches of body cavities, after contact visits may be carried out when there was a need. And 1984, and these are all cases that decided these, by the way. Officials may search cells without a warrant and sees materials found here. So they don't have to like give you advance notice. They can do in that random check. Think about it where you are now. So the Eighth Amendment, dealing with excessive fines or cruel and unusual punishment, pretty much deals with the conditions that take place in the facilities. 76, deliberate indifference to serious medical needs constitutes unnecessary and wanton infliction of pain. So taking care of the medical needs of inmates. Conditions of confinement in the Texas prison are unconstitutional because they had inhumane conditions there in this 1980 case. Double celling and crowding don't constitute cruel and unusual punishment, and you know why, because that's a common status of many prisons to be overcrowded. It says it must be shown that the conditions involve wanton and unnecessary infliction of pain and are grossly disproportionate to the severity of the crime warranting imprisonment. 86, a prison resident mistakenly shot in the leg during a disturbance does not suffer cruel and unusual punishment if the action was taken in good faith to maintain discipline and not for the purpose of causing harm. 91, plaintiffs must not only prove that conditions are cruel and unusual, but also that they exist because of deliberate. So in other words, the conditions are overlooked purposely to treat put the individuals in a situation that would be not good for any human being. 2003, regulations suspending visiting privileges for 2 years for those who have flunked 2 drug tests. And what they were really doing, it was controlling the access to drugs to that individual. Then we get to the last part here about the 14th Amendment and the Equal Protection Clause. In 1968, starting there, in Alabama, the law was used to segregate white from blacks in jail is unconstitutional. And the reason why that changed is because desegregation, but that people should socialize with individuals from different races and so forth. But if there is a gang situation involved, then they might segregate them. But you can't do it. There's a black section and a white section. No, you can't do that. Now, pay attention to what I'm going to say next. The basic elements of procedural due process must be present when decisions are made to discipline an individual. That is, you have a right to a hearing. You have a right to be represented by counsel. You have a right to confront your accusers. You have a right to written information about what the violation or act that they're alleging that you did, those kind of things. So basic due process. Although due process must be accorded, an individual has no right to counsel in a disciplinary hearing. Now, listen to me good. What happened in this situation, if you read it about the case that happened, it was a minor situation. If it's a major situation, and generally disciplinary action doesn't take place, but that the individual is going to end up getting more time, then they would be allowed to have counsel. In 1980, the involuntary transfer of an incarcerated individual to a mental hospital requires a hearing. That's once again due process to determine the state of mind of that individual. And so, and then the right to have counsel, because you're in a mental state, they allege, you should have someone who is not of a mental state to be able to prepare your defense and represent you and speak for you. And then finally, in 1995, prison regulations don't violate due process unless they place atypical and significant hardships on the individual. So in other words, that it puts them in a real bad situation. So these are just some of the cases. There are many more. All right. So now let's look at the Bill of Rights and community supervision. Just a few of the cases, the leading cases, and it goes with some of the things we've already talked about. Griffith versus Wisconsin, a case, Supreme Court case. It said the warrantless search of a prisoner's residence was reasonable because it was conducted based on a regulation that itself was a reasonable response to special needs of a probation system. All right. So the petitioner's residence could be searched within the reason of the Fourth Amendment, meaning of the Fourth Amendment, because it was conducted pursuant to a regulation. Now, that still would mean, if it's within the Fourth Amendment, is that the Fourth Amendment requirements have to be satisfied, which means upon probable cause, and that a warrant issues for the search unless there is an exception that it falls into. 1998, Pennsylvania Board of Parole versus Scott, evidence that would be barred by an exclusionary rule from the use of prosecution in a criminal case can be used in parole revocation hearings. And the reason is because of what I told you earlier. The lesser standard of proof is involved. Remember, I said the standard of proof for violation of probation or parole would be preponderance of the evidence, like in a civil case. All right. In Memphis versus Ray, a 67 case, a probationer does have a right to counsel, and when they're about to have their probation revoked and before a sentencing hearing. Okay. Before a sentencing can be imposed. Morrissey versus Brewer. Oh, I remember this case well. We studied this in constitutional law. I studied it actually in college, but then I studied it more in detail in law school, where the hearing officer determines if there's probable cause, and the person or parolee has a right to be notified, as I was telling you earlier, notified of the charges, know the evidence, have someone speak on their behalf, or they can speak by themselves, present witnesses, and confront the witnesses or cross-examine them. At the revocation hearing, the parolee received notice of the charges and the evidence, just what I said a few minutes ago, cross-examine as well. It's a famous case. Now, pay attention next. Now, the rights established for parolees were now in 1973 added to probationers. So the same thing, right to counsel should be granted on a case-by-case basis depending on the complexity of the issues, mitigating circumstances, and the competence of the probationer. And in most of those cases, it favors the probationer because it's not presumed that the probationer knows the law. So remember, Morrissey has to do with parole, and Gagnon applies the same principles to probationers. That's how you know. Then the last one, Section 1983. I talked about 1981 cases, but 1981, 3 cases where Cooper versus Pate, I remember reading about studying this one as well, means that when a person is incarcerated, they can bring lawsuits against correction officials, but applies not only to incarcerated, but those on probation and parole. Now, of course, you should be aware that there are statutes passed after that to limit lawsuits, particularly for individuals who are incarcerated as well. And we're not going to cover that. All right, but be aware of that. I talk about that in another class that I teach. So now moving right along, correction law and prisoner right activities. So if we click on, I think it's click on this one. Does this one open it? I think this is the one. Okay, no, it's not. We don't go to this one. I think we go, yeah, here it is. You click on that. And then it has a quiz. And you can use that quiz to prepare for your exam. And then here's how the quiz works. You match up. So you match up the following items with their description. First Amendment applies to which one? Which one does the First Amendment, the last one, okay, right to freedom of speech. The Fourth Amendment. The Fourth Amendment deals with cruel and unusual punishment. Is that what you said? Is that what you said? Bad guess. I told you. The Fourth Amendment involves search and seizure. Remember me saying that earlier? Cruel and unusual punishment has to do, I jumped over one. Cruel and unusual punishment has, and bail has to do with which amendment? You already told me. Yeah, it's 8. So then, the 14th Amendment. So you do each of these. Submit it. Watch what it's going to say. Correct. Okay. So then you continue. So you could do each of these. I'm not going to do all of them. So you can do those to help you. Okay, so sentencing and sanctions. So sentencing can be from probation all the way to incarceration. And so remember, and you can receive fines as well. So individuals are held in jail, have shorter periods of time. Notice that a crime that is a misdemeanor will generally have you to serve your time in jail because it's up to a year. If you go beyond a year, then you end up in prison. So it could be a sole sanction or such as shock incarceration, maybe a condition of probation. What is shock incarceration? Where you might be placed in a situation where I had a young man who was locked up in a facility just for a while to teach him a lesson, and the person in there that he thought was trying to take advantage of him, but it was really a guard, and he learned a lesson from that kind of thing. Or you're subjected to something like boot camp or something like that. The goal of community supervision, which is probation, is to keep you out because it's, as I said it before, and I say it many times, it is cheaper to educate than to incarcerate. To incarcerate somebody, you got to feed them, you have to clothe them, and you have to shelter them. So it's more expensive. So probation is better. All right. Intermediate sanctions. start with the least restrictive and go to the most restrictive. All right, and all are enhanced by the probation officer who you report to, and then the more stringent ones you report more, the less stringent you report less. You're going to see in just a minute. So when a person puts somebody on probation, the judge issues a court order, as I said earlier, and it could be as simple as a fine or treatment, whether it's drugs or alcohol. But the failure to comply with the probation may mean additional sanctions, because that's one of the things that they try to do. The last thing they will do is incarcerate you, because it gets, remember, the key thing with probation is to lighten up the load of those who are incarcerated in an already overcrowded situation, as prisons often are. So you could have some additional sanctions added before you finally would end up with going in to be incarcerated. The probationer would no longer have the opportunity of community supervision and must serve the remainder in jail, based depending on the severity of the offense. So it goes from a continuum. It starts out with fines, and then dealing with community service. Community service is where you serve time working in the community. So for example, I know of individuals who had crimes, like for example, that were racially motivated. They served maybe for the NAACP, Operation Push, or some organization. If they committed the crime based upon the person's sexual preference, such as LGBT, they might work in an organization to, and the thing is to help those individuals to get to understand and learn those people. Drugs and alcohol treatment go without saying. If you don't complete those, satisfy those, you got an instant recidivist, because the person, if you don't get to the root of the problem, and drugs and alcohol is the problem, then you're going to find them repeating, because both of those are illnesses. And so you want to treat them for those, to help them to return to a normal life. And that's the goal. Day reporting services is where the person gets services like, as they say, employment, drug or alcohol treatment, and other intervention programs. All right. Drug controls is when, as it says here, you use drugs such as antabase for alcohol abuse, Depo-Provera constrains the sexual male when you deal it, but there are some arguments about that being done with cruel and unusual punishment. And then psychotic disorders, or Prozac for depression. So where drugs are used. Home confinement speaks for itself, where you stay at home, and then there's a GPS that is added, and that you spend your time at home as opposed to being locked up. Shock incarceration, where a person is sentenced to jail, but after a short period, the judge reduces the sentence, assumes jail is distasteful, and that the person will be motivated to remain law-abiding or probation. That's because some people just learn their lesson from that, not very often. And then finally, boot camp, where you're put in a paramilitary situation where you're structured, you have to get up early, you have to make up your beds, you're in a marching and drilling, and you do hard labors, just like you were in the military in boot camp. And so these are tools that the probation officer uses to help individuals to move on in their lives. So here's the role of the probation officer, starting where it's today, it says the probation officer is very much like a police officer and is charged with safety, surveillance, and then supervision and surveillance, similar to that of law enforcement. However, restorative justice philosophies, that is, um, using methods to put that person back on the track to stay out of trouble, and evidence-based practices change the definition of probation and parole and agent work. And then the following, after this, you'll see, provides an overview of the duties and responsibilities over the last 30 years. So we're going to just go through this. And these duties that are derived, as you'll see, you'll notice becomes more like a counselor. That's why you do know, and I will make you aware that in order to be a probation officer, you cannot, in most jurisdictions I know of, I don't know of any, and maybe you do, where you can become a probation officer with an associate's. You have to at least have a bachelor's degree. And the reason is because you're going to be doing various things. You're going to deal with contacts with the individual. You're going to do what we call pre-sentence investigations. That's so that you can determine to what extent that individual's criminal history, any violation reports that they violate the conditions, probationer moving the individual from one jurisdiction to another, and then pre-sentence investigations, as well, pre-release rather, from prison investigations, similar to this, and court appearances that probation officers do. So they testify just like police officers. Then by 1996, their duties noted before went up, and you could see progress reports, mini reports, bail evaluation, sentencing guidelines, and on, and you can see program monitoring, community service work referrals, gambling assessments. So then you start to move into being a counselor. By 2009, in addition, notice the things that are involved here. And you start to move into higher levels where you deal with assessment and testing, interviewing for skills, sex offender registration if you're a person, intensive supervision, intensive supervision where you have to report more than normal. Electronic monitoring, you know what that's about, GPS, and actually ankle bracelets and things of that nature. And then diversion programming. And so now we've moved up to all of these different things. And if you pay attention to each of these, it now lets you know that you're basically a full-fledged counselor for the individual. Now, remember the things I told you earlier, they didn't do away with them. They just added these additional things. And that is why now that probation officers have to at least have a bachelor's. The role of probation officer today is referred to as a change agent. So the probation officer is not only responsible for public safety, but also for working individually to help them with skills and address criminal thinking, not critical thinking, but change the direction of the individual. Today, the community is believed that the probation officer is much like that, and then this is the start of it all over again. All right, so, and then I added these other things to it, showing you from that point on. So that's the probation officer. So now the final thing before we adjourn is your vocabulary review, which you normally have. And I recommend going through that as well as the other thing that I shared with you, is to put these through together. match the items with their descriptions. We're just going to do this one. What are the legal rules produced by judges that serve to guide the decisions of other judges? What do we call that? We talked about that earlier. Case law. That's what you say. Okay. See if you're right. A judicial policy of non-interference of the internal administration of prisons. What do they call that? And that was in the early stages. Hands off. And then, of course, procedural due process guarantees that no agent or instrumentality will use any procedures other than those prescribed by law. So let's see if you're right. Yep. So you do this with the others as well, and that helps you to prepare. Any questions? Okay. Well, we're at the end. We're at the end. So I see no questions there. So I'm going to give you a key phrase. Anybody have any suggestions for what I might give you? What I have in mind? Any? Nope. How about the overall theme of the module? What's it about? Nope. Nope. It's 2 words. Okay. I won't make you guess anymore. How about probation officer? Isn't that pretty much what the whole, I mean, we talked about locking up and things like that, but isn't that the essence of it? Yeah. Mm-hmm. Yep. So give me that probation officer and you get your points. All right. So I'm going to say good night to you guys. Continue to stay safe. It's still pretty dangerous out there. I've been hearing that there's still people out here who want to inflict violence on individuals. It's really sad, tragic. And then we got these various strains of COVID-19, and I'm in line in my state because of my age to get that shot. So I am definitely going to take the shot. As somebody said, well, what about side effects? I says, well, one thing I know for sure, the side effect possibly of COVID is death. Not too many people have taken the shot and died. Now, some have, but then they found out later it wasn't from the shot. It was other things that caused them. So I'm taking the shot. I'm taking the shot. Wear your mask. You see, they're talking about even now going to the point of wearing a double mask because it should have more than one layer between you and that individual. And I just ordered a whole bunch of N95 masks. You all know about N95 masks? You heard about N95 masks? Have you? Have you ever heard of N95 masks? Mm-hmm. Yeah, N95 mask or K95 provide the maximum because they said that what happens is that the mask fits tighter around the nasal area and seals in. Some of the other cloth masks, that's why those bandana things, I don't like them at all, is because it doesn't protect you as much. So I just ordered 2 cases of those for my family, and they're disposable, so. Well, all right, guys, get the assignments in. Pay attention to everything that I've said this week. If you have any questions, you know what to do. Let's get those assignments in, because we are winding down. Time is winding up. This course is almost over. The 9th, as I said, ends. And what happens on the 10th? You guys know what you're taking term 2? Do you know what you're taking term 2? Do you? Do you know what classes you're taking next term, which starts the 10th of February? Do you know? You got it written down somewhere. Well, if you take Introduction to Criminal Law or Drugs and Crime, chances are you'll see me again, because those are the 2 that I'm teaching during that period. So usually those are pretty heavy enrolled classes. So Drugs and Crime and Introduction to Criminal Law. Okay. I think it's J150 for criminal law. They have another number too, or J250 for drugs and crime. All right, I'll see you next week for our final lecture. So enjoy the rest of your week. Again, okay, stay safe. Keep me in your prayers, and anything you need, even though I'm dealing with what I'm dealing with, feel free to reach out to me. Unless I'm in a situation where I can't answer you, I'll get back to you. But say, okay, I'm going to say good night.